Back on the record in the State versus B.J. Brown for day 3, I want to deal first with the requested changes, if any, of the charge that was drafted, and would simply suggest that I received an email from the state, which was copied to the defense, and in it, the state had requested 2 additional instructions, or a change in 1 instruction and 1 additional instruction. Those changes are that the state requested a flight instruction, which I think was 47. Flight instruction is 42.18 in the Tennessee pattern jury instructions. And then the other change was to change the language of the elements of attempted first-degree murder, which is located on page 3 of the draft of instructions. In part 2 of that, they want to change to a different section of that particular pattern jury instruction. I find that, and I will be glad to hear any argument that you wish to hear, but those are the 2 changes that I've received from the state. So, Mr. Crouch, do you wish to make any other argument about any other change, or Mr. Turnbow, either one?
Judge, the reason for the change in the attempt part of the first-degree murder, looking down at the comments specifically referred to a shooting that did not result in the death of a victim as it relates to 4.01B as opposed to 4.01A. That's the reason we're asking for that change in the attempt.
I have no objection to that particular change, Your Honor.
All right, that change will be ordered. It will be operating under that requested section rather than the language in the first draft. So then we go to the flight instruction. State wish to be heard is fairly speaks for itself, but
we'll just rely on what we put.
What they've requested in the email was that even though he is charged in one of the other counts with the commission of or the use of a weapon in a flight to avoid, or flight from, I forgot the exact language, but in any event, because flight is an element in one of the other charges, they're asking that it be limited to count 1 of the indictment in the instructions. Mr. Spratt, do you have anything you wish to say to that? I know you have a motion to make about the count 1 anyways.
I do. I guess we can take that up all at the same time.
Yes, let's go ahead and deal with everything.
Judge, we have an objection based on the language in this indictment that the jury should not be instructed as to attempted first-degree murder based on the way the language in this indictment, as it says that the defendant then and there unlawfully, knowingly, so forth, deliberately, feloniously, and with premeditation, attempt to kill Officer Darrell Tabor. That indictment has been read to the jury. There was an amendment the state wanted to make prior to the trial, prior to the jury being sworn, regarding the indictment, which the defense objected to. And afterwards, during the reading of the indictment, an incorrect mens rea has been read to the jury regarding this count. And so I feel like if we now instruct them on that, they've read, they think that this, if we're talking about the second degree, the lesser included charge to the jury, they've already been exposed to this knowingly language. I don't know how that can't confuse them as to how they can find guilty of attempted first-degree murder based on a knowing mens rea. It dispenses with an essential element of first-degree premeditated murder, which says in the statute says premeditated and premeditation and intentional. I'm assuming the reference to the first-degree murder statute it doesn't reference a specific subsection of that statute. It just references the first degree murder statute. I'd kind of like to add in there that it says, when read as a whole, knowingly, deliberately, feloniously, and with premeditation, attempt to kill Officer Darrell Tiber while acting in his capacity as a law enforcement officer, comma, as defined in TCA 3913-202, comma. The way this indictment reads is that's where the definition of a law enforcement officer is. And so you couple that with the defect that was cured over objection, where we reference, or the state referenced the wrong statute, and then you've got an indictment where you're supposed to rely on the statute one, but then you've got the wrong statute in the other. So we have the inverse problem here. I think it's dispensed with an essential element of the offense, and the jury's heard it. And so for that reason, I object to the jury being instructed on attempted first degree murder. And
Crouch?
I'm sorry.
Briefly, the state, General Crouch has provided a couple of opinions. I think they're both from this jurisdiction, one of which I believe is Judge Lockhart Mash's. I haven't had a chance to review that, but my understanding is that those are unreported cases. I'm trying to review those real quick, which would make them, possibly persuasive once I review those in context, but not mandatory authority for this court to follow. So for those reasons, I would ask that the court.
And the essential, so that we're clear on the record, the essential element of the first degree murder charge that you're saying is omitted in this indictment is what?
Intentional.
Okay.
And
they use the word deliberately.
it says deliberately, but I mean, that's not a, I don't think that's a substitute for the plain language of the statute. So, briefly again, with no subsection, I've read some case law where a subsection, a reference to a subsection, could cure that. With, I think the cases I read were with respect to the to 3917, 417, the felony drug statute, and those cases references a specific subsection. If you're pointed in that direction, then you're on notice. But if you're just pointed to the general statute, there's, I believe, 4, maybe 5 different theories for first degree murder. So couple that back with the knowingly mens rea that's put in there, I think, and the jury's going to be instructed on knowingly, on the lesser included. So it's going to lead to confusion, to where they're getting an instruction as to what it means, but they were read an indictment that has that same language in there. So those are, for that reason, I'd ask that they not be instructed on that. And I can reserve, and we can argue about the extra flight instruction, or you want me to go ahead and handle?
What is your objection to the flight instruction?
Well, if an element of the offense is already there, then, and
It's an element of the offense of one of the other counts.
It is.
Not the first degree murder count.
It is. So, I mean, the jury's already going to be instructed that he's on flight.
There's a different definition. The instruction on flight has to do with an inference of guilt that arises because someone fled the scenery or the scene, and that they can use that as, if they choose to determine, the intent and guilt of the individual. I mean, the language is pretty clear. It's different than, the instruction on use of a weapon to facilitate their escape from arrest. So I wanted to make sure that you're understanding. What they're asking is only to include that flight instruction in reference to count 1 rather than
Yes.
the other counts.
And I understand that, Your Honor, and other than these issues that we're taking up now, I got the email last night from General Turnbow to Your Honor and Ms. McKinney and myself. It was later on in the evening, but I have not had a chance to go back specifically review the flight instruction. So other than the issues that we're taking up now,
PPI 42.18 says the following. The flight of a person accused of a crime is a circumstance which, when considered with all of the facts of the case, may justify an inference of guilt. Flight is the voluntary withdrawal of oneself for the purpose of evading arrest or prosecution for the crime charged. Whether the evidence presented proves beyond a reasonable doubt that the defendant fled is a question for your determination. Then it goes on to talk about the law makes no precise distinction as to the manner or method of flight. It may be open, or it may be hurried or concealed departure, or it may be a concealment within the jurisdiction. However, it takes both a leaving the scene of the difficulty and a subsequent hiding out, evasion, or concealment in the community, or a leaving of the community for parts unknown to constitute flight. If flight is proved, the fact of flight alone does not allow you to find the defendant guilty of the crime alleged. However, since flight by a defendant may be caused by a consciousness of guilt, you may consider the fact of flight, if flight is so proven, together with all of the other evidence, when you decide the guilt or innocence of the defendant. On the other hand, an entirely innocent person may take flight, and such flight may be explained by proof offered or by the facts and circumstances of the case. Whether there was a flight by the defendant, the reasons for it, and the weight to be given to it are questions for you to determine. That's the instruction. And with all due respect, this court finds that that is in fact proven by the facts in this case, and that it is warranted as an instruction for this jury regarding count 1, and it will be inserted after the definition of the elements of murder, of attempted first-degree murder, and that will be how it will be presented.
okay. And Your Honor, just briefly, I understand the court's ruling. Just part of my objection to that is that I don't think there was any
So you want
proof.
to talk me out of it?
No, I'm not going to talk you out of it, Your Honor. I don't believe so. I just want to put it on the record that our objection to that is that there's been no.
All right, your objection
proof.
to that instruction being included, especially as it relates to count 1, which you object to anyway, is noted. So,
Yes, thank you, sir.
anything else then about the charge itself, other than you're going to argue about his request to not charge him on murder in the first degree, Mr. Crouch? You have case law that you're saying that relates to that?
Your Honor, I'd like to provide the court with the 2 cases. I've already provided those to Mr. Spratt. One is State versus Ariel Robinson, Christopher Duncan, Timothy Schaffner, unreported, but it's out of Cheatham County, issued opinion filed on March 17th, 2021. And another case that Your Honor is familiar with, State versus Trevor Wallace, which we've leaned on a couple of times, out of Houston County, which I believe Your Honor presided over. But the first case is the most
Trevor
important.
Wallace case is the one that I granted the defense motion to dismiss the case based on the faulty indictment.
Yes, sir.
I remember it well.
Yes, sir.
And the Court of Appeals disagreed with my interpretation of the language of the statute.
They did, Your Honor, but that one is kind of secondary to the first case, and I want to kind of refocus on the purpose of the indictment is to give the defendant notice of what he's being charged with. It's not to instruct the jury on the elements of a crime. As Your Honor is aware, we heavily redact indictments before we even read them to the jury. They're not hearing a lot of the language that's in the jury because we don't want to risk causing a mistrial by saying the words "a felony." But regardless, here's what the current indictment as presented and as read to the jury gives notice of to the defendant. 1, the indictment alleges premeditation. 2, it cites the first-degree murder statute. 3, it cites to the attempted statute. 4, attempted first-degree murder is listed as a name charge on the indictment, on the back of the indictment. 5, switching away from the indictment, we filed an amended notice of impeachment to Mr. Spratt, which clearly cites attempted first-degree murder in our range and notice of punishment. Multiple things give the defendant ample notice of what he's being tried for. We've had hearings, Your Honor, in this case where Mr. Spratt is arguing about the punishment in this case because it's an attempted first-degree murder of a police officer. There can be no dispute, no I mean, Mr. Spratt's not disputing what his client's charged with. He's simply arguing that the jury may get confused by the wording of the indictment. Well, that's not what an indictment is for. The indictment is simply to put his client on notice of what he's charged with, and that's what has been done. But going to the Robinson, Duncan, Schaffner case, almost the identical situation occurred in Cheatham County, where the indictment,
It's the identical language.
and here's why it's the identical language. And the courts wouldn't know this, but statewide, a system is used to auto-populate indictments when they're created. And maybe it is archaic language, but it is what it is, and it can be manually corrected. It's just so happens that statewide, we are changing to a new version of our case management software. So all of that will change. But regardless, it's the exact same case. And the court ruled that the additional language of deliberate does not invalidate the indictment. If anything, the additional element of deliberately created a higher burden for the state to overcome in order to secure an indictment against the defendant for first-degree murder. This indictment is not faulty. This case, in fact, the Cheatham County case, the indictment did not list the statute for first-degree murder. It only referenced the attempted statute, and they still ruled that it was enough notice to the defendant to put him on notice that he was being tried for attempted first-degree murder. It actually left out the first-degree murder statute 3913-202 and simply had the language of attempted. So the current indictment that we have clearly is sufficient to put the defendant on notice of what he's being tried for. But I will refer to the Wallace case for just a moment, simply to say that if Mr. Spratt were to win this argument, the remedy is he doesn't just win and walk away. Double jeopardy doesn't attach because, as Wallace refers, Mr. Spratt intentionally waited till after the jury was sworn to bring this issue up. So when the defendant intentionally waits till after the jury is...
I object to that. There's nothing that says that I've intentionally waited until anybody was sworn in to do this.
Judge, we had Mr. Spratt told me he was aware of the language.
That's not
This is
true.
argument of counsel. I take it for a grain of salt that it is.
But
Well, regardless, he waited. I'll retract the word intentional. He waited until after the jury was sworn to make his motion. So the remedy is a mistrial, but double jeopardy doesn't attach because he waited until after the jury was sworn. So we would just be trying this case again.
may I rebut some of that, please?
Certainly.
I didn't wait. What I told General Crouch was that I noticed the defect as far as the attempt statute, as far as the statute. That's a clerical error in the indictment. I told him, in fact, exactly what I told him is that I noticed it 12 months ago. That's a clerical error. The court is always going to, just like the court did over my objection, allow him to amend that part of the indictment. That's a clerical error. That's clear. I don't think the court erred in allowing him to do that. And I probably wouldn't even allege that in a motion for a new trial. But what happened is you're sitting there combing through this thing afterwards, and then it's read to the jury under knowingly. But that's not what I told him, so I don't appreciate that at all.
You think that this disagreement between you and Mr. Crouch influences my decision on the motion one way or the other?
No, Your Honor, I don't think it influences your decision, but we're in a court of law, and he's saying I said something that I didn't, and I do take personal.
He didn't say you said it. He's basically saying that you'd waited until after that you didn't write. The fact is that this motion was made after the jury was sworn, and that's the point of significance in this court's opinion, because the Wallace case, which I presided over and granted the motion to dismiss after the jury was sworn based on my reading of the language of the DUI statute, and the criminal court of appeals reversed it, sent it back for a trial because of the fact that they said, number one, the language of the indictment was clear enough to put the defendant on notice of what he was charged with, and number two, that jeopardy didn't attach because the motion was not made until after the jury was sworn. Those types of motions and defects in the indictment typically are made before the trial begins. And that, whether you appreciate what General Crouch is saying and the way he said it, is not the issue before the court. Both of you are very able lawyers. Both of you are very impassioned for your side of this dispute, and I respect the fact that both of you take your job seriously. But it is my job to rule on the sufficiency of the indictment, and whether you agree with what he characterized or not doesn't change my decision in the case. So having given you the opportunity to respond, if you'll have a seat, I'm going to rule on this.
Thank you, Judge.
Judge, may I say one thing?
Is it going to change my ruling?
No, it's not. On the record, I certainly was not trying to insinuate anything nefarious on Mr. Spratt is a very honest, good. I gave him a recommendation on Google. It's fantastic just this week. So I did not mean to imply anything bad
So
about Mr. Spratt.
maybe I should have the two of you hug it out here in the court.
I mean, no, I was not trying to do that, Judge, so.
All right. And as I said, lawyers are oftentimes in the courtroom, and I've been in that same situation many times myself. I'm reminded of the story of a friend of mine who was hired to represent a defendant, and General Dan Alsterbrooks was the DA over in the General Sessions Court. And this lawyer was hired on a DUI case, and so he said, "I'm really going to." He and General Alsterbrooks were very good friends. They went in for a preliminary hearing, and they went at it hammer and tongs. I mean, they were really going after each other. When the case got bound over to the circuit court, the lawyer was feeling pretty good about the job he had done. They walked outside, and the client said, "Well, I'm sorry, but I'm going to have to hire a different lawyer." And he goes, "Why? What did I do wrong?" He says, "Well, so the only reason I hired you is I thought you and General Alsterbrooks were friends, and you obviously can't stand each other." So that's the way lawyers operate. They have to present their cases in an impassioned way and do it because they believe in their cause. And Mr. Spratt has certainly shown that he is doing everything he can to represent his client within the bounds of the law. General Crouch is doing the same thing from the state's position. I don't take any offense in the fact that the two of them have tried this case in a very professional way, and sometimes our passions get the best of us. So that doesn't help me what goes on between the two of you in deciding the case. What does help me is the instructions given by the Court of Criminal Appeals. And as I referred to the Wallace case, General Crouch is correct. That case clearly indicates that if I do grant your motion to dismiss that indictment, then, or to dismiss count one of the indictment, the state can simply go back to the grand jury, get another indictment, and come back in and try him on that charge again. I do not believe that that is in the best interest of the parties. And the reason for that is because in this other case, which is the state of Tennessee versus Ariel K. Robinson, the Court of Criminal Appeals made certain observations about the indictments that are returned in cases. And they state, and I'm referring to page 17 of that opinion, indictments are reviewed from an enlightened standpoint of common sense and right reason rather than from the narrow standpoint of petty preciosity, pettifogging technicality, or hair-splitting fault finding. It goes on to say that in this case that I'm dealing with, the Robinson case, the language of the indictment was exactly the same as the language in this. It was an attempted first-degree murder case, and the language in that stated exactly the same thing as this indictment states, that the grand jurors of Cheatham County found that the defendant then and there did unlawfully, knowingly, deliberately, and feloniously, and with premeditation attempt to kill Frank Burnett. And this particular situation, that's the exact same language that's used here. The Court of Appeals, the Court of Criminal Appeals, in that Robinson case went further on page 18 to state the following: the additional language of deliberate does not invalidate the indictment. If anything, the additional element of deliberately created a higher burden for the state to overcome in order to secure an indictment against the defendant for first-degree murder. Accordingly, any error in the grand jury process caused by the addition of deliberately in the indictment ran to the defendant's benefit, not his detriment. Further, the indictment clearly states that the alleged offense occurred with premeditation and was a Class A felony. And that, under my reading of this indictment, is exactly the same situation we have here. The jury, when they deliberate this case, will be given in the final charge, as you've seen, all of the elements of first-degree murder and all of the elements of the attempted first-degree murder. So they're going to be instructed on the law correctly, and the indictment itself is intended to give notice to the defendant of what he's charged with, as well as to set the case before the court. So for those reasons, the court denies the motion to dismiss count one and finds that the count one of the indictment on attempted first-degree murder is a valid indictment and a valid charge and should go to the jury. Now, having resolved the issues regarding the charge, we're going to make the charge that I've given you with those two changes, flight and the second section on that other section. Those two changes are the only changes I'm making, and I'll then have that printed and we'll be ready for presented to the jury. Mr. Spratt, you backed up, so I assume that means you're going to stand up. So.
Do you know, Your Honor, what, are we going to print those now before we bring the jury in, or are we going to get those,
Print what?
the instructions with the changes?
Well,
I got
it's gonna
several
be-
copies, and
It's going to be, we have a jury sitting back here
Yes,
that's been waiting since 8:45, an hour waiting to take this case back up. We're not going to print that before the jury. We'll give you a copy of it before you make your closing statement. What we're going to do is we're going to conclude whatever issues I have to take up outside of the presence of the jury. Then we're going to bring the jury back, conclude the state's proof, offer the defendant an opportunity to present any proof that he may want to, although he's not obviously required to. And when that is done, I will then make copies for everyone of the final charge, and then we'll let you have your final argument, and we'll go from there. Anything else? All right, then let's take up whatever other issue there is to be heard outside of the jury's presence.
Judge, we're going to have a brief out of jury out hearing on the issue of some recordings from the Dixon County Jail.
All right,
And the state's first witness in that will be Deputy Howell.
Deputy Howell, raise your right hand and let's place you under oath.
You solemnly swear or affirm that the testimony the whole truth and nothing but the truth.
Good morning. Will you state your full name for the court, please?
Deputy Greg Howell,
Can we spell your last name?
Howell,
Where do you work?
Dixon County Sheriff's Office.
How long have you been employed there?
Almost 11 years.
And have you ever been employed in the corrections and jail area?
Yes, sir.
And how often have you worked there?
First 4 years at the Sheriff's Office.
Okay. So are you familiar with the booking area of the Dixon County Sheriff's Office?
Yes, sir.
And are you familiar with the booking area where the defendant in this case was housed?
Yes, sir.
Are there individual cells within the booking area?
Yes, sir.
Are there cameras within those cells?
No, sir.
Okay. So if somebody is inside of their cell, there's no camera?
No, sir.
And do y'all put audio recorders inside their cells?
No, sir.
All right. Is there a video surveillance camera like we might see in the courtroom in the general area of booking?
Yes, sir.
All right. It records video.
Yes, sir.
Does it record audio?
No, sir.
And it never has?
No, sir.
All right. I'll pass the witness.
Mr. Spratt, do you have questions?
No questions.
Thank you, Officer Howell. You may stand down and resume your duties.
Yes, sir.
You may call your next
State
witness.
calls Aaliyah Brown.
Brown. Deputy Brown, if you'll come back around, I'm going to ask you to be placed under oath again, please.
You solemnly swear or affirm that the testimony in this case the whole truth and nothing but the truth. So help you God.
Deputy Brown, will you state your full name again, please?
My name is Aaliyah Brown,
And spell your last name?
Brown.
Thank you. And are you employed at the Dixon County Jail?
Yes, sir.
And what do you do there?
Well, not at the jail anymore. I'm in the patrol division, but at the time of the incident, I was.
So I want to refer you to September the 20th, 2023 through September the 28th of 2023. Were you employed at the jail at that period of time?
Yes, sir.
I think September the 20th of 2023 was the intake date for the defendant, B.J. Brown, in this case. Does that seem right?
Yes, sir, I believe so.
All right. Was he just being housed temporarily at the Dixon County Jail?
Yeah, as far as I know, he was here for court.
So an intake date of September 20th, 2023, and a release date of September 28th, 2023, that would be the 8-day period that he was kept at the Dixon County Jail?
Yes, sir.
All right. So you created a report that was testified to yesterday that says on September the 22nd, 2023, I, Corporal Brown, was conducting a security check in booking when inmate B.J. Brown asked that his pie flap be opened.
Yes, sir.
First of all, September the 22nd, do you think that's the date this incident happened, or is that date wrong?
I think it's the 21st.
Okay. One way or the other, it's the 21st or 22nd.
Yes, sir.
Did you approach the defendant's cell?
Yes, so with a security check, you scan a tab on each cell and booking and mark what they're doing, laying down, sitting on bunk,
Okay.
things of that matter.
So you had to actually look into his cell?
Yes, sir.
And to your knowledge, there's no video cameras inside an individual cell?
No, sir.
All right. Were you wearing body camera at this time?
I was, but they don't run continuously.
Okay. So when you had this incident with the defendant, you didn't have body camera running?
No, sir.
All right. So there was no recording made?
No, sir.
And
Not as
no-
far as I know.
No recording to be preserved?
No, sir.
All right. And there was no camera in his cell?
No, sir.
Okay. I'll pass the witness.
Mr. Spratt?
Why, Deputy Brown, why is it that you weren't, your body camera wasn't running at that time?
That's not part of policy within the jail. If an incident occurs, then we're to turn it on, but it's not like the typical Axon cameras.
Okay, so you manually activate that if
Yes, sir,
something's
you
going
do.
on?
You do.
Okay. And somebody had just threatened to shoot you
Yes, sir.
and you didn't turn it on?
No, sir. It was conducting a security check. You don't typically record those.
Okay. And who did you talk to about this? First.
Lieutenant Hoope.
Lieutenant Hoope?
Yeah, she's no longer with the jail, but she was the security officer at the time.
Okay. And what day did this happen on?
I believe it to have happened on the 21st.
You believe it? Is that just from your memory?
Best of my recollection.
Best
yes,
of your
sir.
recollection? Okay. And how long after that point did you go report it to Lieutenant Hoope?
I mentioned it to Hoope that day. When the warrants officers came to get Mr. Brown for court, it was communicated to them. They communicated up their chain, and that's when Captain Andy Davis requested that it be notated.
Okay. Did you speak with anybody else about it other than?
No, sir, not to the best of my recollection.
Okay. Did you ever speak to Deputy Epps about it?
No, when I relieved Epps that morning, he mentioned threats had been made, but that was the scope of it.
That's all the Deputy Epps said to you?
Yeah, that threats had been made towards him.
Same day?
I relieved him that he worked a night shift, so I'm unsure if it would have fell before or after midnight.
But one
yes,
shift
sir.
right after the other?
Yes, sir.
Okay. And so that's when Deputy Epps says to you, he's made threats to me, and this is on September, you believe September 22nd
Yeah.
or 1st, somewhere in
Yeah, I
there?
relieved him from the booking post, so to speak, so he kind of gave me a rundown of, events that had happened the previous shift.
You had no further interaction later that week with Mr. Brown?
When the warrants officers came to pick him up for court, of course, I took the keys over there and they handled it from there, but outside of that, no, sir.
Okay. And that, I'm talking about like the 6-7 days later when he was about to be transported, you had no,
I didn't, as far as communicate with him, not really, sir.
with Mr. Brown?
Yes, no, sir.
Okay.
No, sir.
What about Deputy Epps? Did you have any communications with him later in the week about it?
No, sir.
Okay. Those my questions, Your Honor.
Any redirect for her? All right. Before, let's go ahead and have her step off. Is there anything else about this issue before we bring the jury in then? She was testifying yesterday when we adjourned for the day. Any reason that we can't just resume from that point? All right, let's bring the jury in. You can just stay where you are. So. Ladies and gentlemen, thank you for your patience. These delays that we have where you are left sitting back in the room are my fault. You should not attribute that to either one of the parties in this case or hold it against them one way or the other. I leave you back there so that I can deal with things that I think are important to be done outside of your presence. So please, if you're going to hold it against anybody that you're back there twiddling your thumbs, hold it against me and not either one of them. So, all right. We had adjourned yesterday during the cross-examination of Officer Brown, and Mr. Spratt was questioning her about something, and we adjourned to allow that to be investigated. That's been done, and we are now ready to resume the cross-examination. Officer Brown has already, or Deputy Brown, has already been sworn in this morning, and so she is under oath as we proceed. So, Mr. Spratt, you may resume your cross-examination.
Thank you, Your Honor. Deputy Brown, you say that Mr. Brown made these statements on is it September 21st?
Yes, sir, I believe it to have been September 21st.
Okay, you believe it to have been September 21st. And you, around what time of day?
I know it was before lunch.
What's
So-
your shift? Just,
At that time, my shift was 0700 to 1900.
okay, so the military time that was my next question.
Yeah,
So-
sorry, 7
no,
to 7,
no,
12-hour
that-
shifts.
Okay, all right. So you came in at 0700, which is 7 a.m., right?
Yes, sir.
On the 21st, right?
Yes, sir.
Okay. And may I approach again, Your Honor?
Yes.
Briefly. I'm going to ask you to review that again and in your head and not read it out loud.
I got you.
Can you? Do you believe it may have been September 22nd?
I think it was the 21st, sir.
Okay, so are you saying there's a typo in your
I believe
report?
so,
'Cause
sir. I think the correct date is the 21st.
So you believe it was the 21st?
Yes, sir, I do.
Okay. And when an incident occurs, you wear body worn camera?
Yes.
I mean, let me back up. You just generally you wear body worn camera?
Yeah, it's separate from the Axon again, but it is a body camera.
Okay. And when an incident occurs, you manually activate that, right?
Yes, you do, sir.
Okay. And so you did not manually activate that camera?
No, sir. Not in conducting a typical routine security check. No, sir.
Okay. So then you didn't feel threatened enough to where it was an incident that needed your body camera turned on, did you?
No, sir. I didn't go back to his door and,
Okay.
continue the situation.
Okay. Those are my questions, Your Honor. I'll pass the witness.
Turnbow.
So, Deputy Brown, just to reiterate, you don't know Officer Teeber at all, do you?
No, sir.
Okay. And this thing that we're talking about here occurred in Dixon County?
Yes, sir. It did.
All right. And there was a door between you and Mr. Brown, wasn't there, at this time?
Yes, sir. There was.
And so was the statement made like through a flap in the door or something of that nature?
The flap was closed. The door was closed. So through the door, yes, sir.
And what was the statement he made to you?
He said he would shoot me just like the other cop.
Nothing else, Judge.
Recross.
And language like that did not cause you to feel that you needed to videotape this?
No, sir. Like I said, I didn't go back to the door nor try to argue further with the situation. Just let that be the end of it.
And you believe you put the wrong date when you reported it?
Yes, sir. I believe the correct date to have been the 21st of September.
Have you talked to anybody else about this since it all happened?
No, sir.
You've never mentioned it again?
No, sir.
Have you talked to anybody about it in the last 24 hours since you were here, since we were here? Well, not 24 hours. Have you talked to anybody about it since yesterday?
I spoke with my FTO that I'm currently with, and just kind of let him know what happened while I was here on the stand, but outside of that, no, sir.
Okay, so you did discuss your testimony then?
With my FTO, yes, sir.
Okay. Those are my questions.
Who was your FTO, Deputy Brown?
Epley?
And he's
Yeah,
not related to
Epley.
this case or a witness in this case, or has anything to do with this case?
No, sir.
All right, that's all.
Anything further? Thank you, Deputy. You may step down and you may resume your duties.
Thank you, sir.
They may call your next witness.
Judge, that's the conclusion of the state's proof and the state rests.
All right, state rests. Ladies and gentlemen.
Good morning again, ladies and gentlemen, and thank you for your attention through this trial. I know sometimes it's probably tested your patience, but I do appreciate your good attention through the trial. On the evening of June 27th of 2022, Officer Daryl Tieber, sitting right there, got ready for work. He's a police officer for the city of Erin. He put on his patrol uniform, marked uniform. He testified just like the one he's wearing there, except with short sleeves. Got in his marked patrol car with blue lights equipped on it and went to work to serve the citizens of Erin, Tennessee. This was a normal evening for him, but it wasn't going to turn out to be just any other evening. Before the evening was out, Officer Tieber was going to have a terrible thought run through his mind. You heard him testify right there on the stand. After those first 2 shots were fired, I thought I was going to die. He made an ordinary traffic stop on B.J. Brown, the car he was driving. He made a traffic stop because he couldn't see any license plate on it. It was Officer Tieber's job to look into that, serving the citizens of Erin. So he makes the traffic stop, and what happens?
Sit down in your car, sir. (106 Central). Car didn't.
A couple of things I want you to note about that video. Officer Tieber has the microphone in his right hand. He is mid-sentence when these shots start. See, to him, this was just an ordinary traffic stop, but this man had other ideas in mind. He'd already made preparations for what was going to happen. Officer Tieber didn't know it. It was just an ordinary traffic stop. You see him mid-sentence have to throw the microphone down, grab his service weapon, and return fire. Done amazingly quickly between his training and adrenaline and thinking that he was going to die.
Stay in your car! Stay in your car! What's wrong? Stay in your car, sir! What's wrong? Stay in your car! What I did? I will tell you. Stay in your car! Come on! Stay in your car, sir!
A couple other things I want you to note about this video. Mr. Brown pulls up almost all the way to the fence at McCaskill Construction. And what does he do immediately upon stopping? He immediately gets out of the vehicle and engages the officer verbally. And he does this for several seconds giving him time to calculate, giving him time to plan what he's going to do next. And he sees the officer's reaction because he's standing up, he's outside of his vehicle, he can see what Officer Tieber is doing. And he knows Officer Tieber engaged him. You hear it multiple times, sit down in your car, sit down in your car, I will come to you. And then Officer Tieber sits down in his car and gets on the mic, all of which B.J. Brown can see because he's standing up outside of his vehicle. So this is what we're talking about today. An attempt to unlawfully kill the victim, Officer Tieber, done with premeditation while Officer Tieber was performing his law enforcement duties. Oh, we know number 3. We see the blue lights in the video. Officer Tieber's making a traffic stop. He's got his uniform on. He's in his marked patrol car. But I want to take the other 2 one at a time and just go over a few things with you about each one of them. And the first thing here, I want to point out 14 shots. This man fired 14 shots out of that rifle at that officer. 14 shots. While Officer Tieber is sitting in his patrol vehicle and Mr. Brown is outside. I want you to look at this. This is the dash cam video, and it's slowed down. And I want you to pay attention carefully to Mr. Brown's first 2 steps. I want you to look and see what it, and I'm going to scoot out of the way so you can see very good. Where were Mr. Brown's first 2 steps? Were they running away? They weren't running away. They were going at Officer Tieber. He moved a little bit away from the car, but his steps were towards Officer Tieber's patrol car. He wasn't running away. He had intent to kill Officer Tieber. He moved towards him. He fired 14 rounds. Now, after that, you see him kind of hop to the side. But I want you to remember, what happens after he fires 2 shots? Officer Tieber is able to throw down the microphone, get his service weapon, and start returning fire. See, Mr. Brown at that point no longer has the advantage. He's no longer the only one standing out with a rifle shooting. Officer Tieber is able to return fire, possibly saving his life. And Mr. Brown takes off. That's when he leaves. He doesn't get out of the car and run. He gets out of the car and goes towards his patrol car trying to kill him with his 14 shots. Next, I want to talk a little bit about premeditation. And like I told you in the beginning, the judge is going to give you the law, and I expect that this will be what the judge tells you, a part of it, about premeditation. A premeditated act is one done after the exercise of reflection and judgment. Did he have time to exercise reflection and judgment? Premeditation means that the intent to kill must have been formed prior to the act itself. It's not necessary that the purpose to kill pre-exist in the mind of the accused for any definite period of time. So those are the things that we're looking at for premeditation. This is that second element that we looked at on the 3 elements. If we go to the next slide, I want to talk to you a little bit about what Mr. Brown's actions were. See, none of us here can read minds. There's been some talk about this in the trial. So how can we tell what a person's intent was? The way we can tell is we look at their actions. We look to see what they did. We look to see what this man did. He obtained a rifle full of rounds that was described by the expert as penetrator rounds while he was in Louisiana. He got a rifle that was full of rounds for penetrating things, and he drove from Louisiana to Tennessee. And you heard in his interview that took him several hours. It took him all day, giving him plenty of time to reflect, plenty of time to think about what it was he was going to do. Why did he have that rifle? On his interview, he said that he was going in Memphis to visit the memorial for young Dolph. But you heard Special Agent Angie Valley testify as far as where he went. He didn't spend any time in Memphis. He drove straight through. I think Agent Valley testified he may have stopped at a red light or something, but the time was consistent in driving straight through. He didn't go to that memorial. That's not why he had that gun. He drove all the way to Erin, Tennessee, where something happened that he didn't know when or if it was going to happen, but he'd had time to think about it. He'd had time to plan what he was going to do. And then Officer Teeber pulled him over. He'd had hours to reflect on this situation. What's going to happen if this happens? So he sees McCaskill, he pulls almost all the way up to this fence. What's behind the fence? Woods. There's nothing back there. Again, he still has time. And then what does he do? He gets out of the car immediately and engages the officer. What's he doing now? Well, we talked about the reflection and judgment. Now is his plan to kill Officer Teeber. He's had time to reflect on it. Now we're getting towards the implementation of this plan. Gets out, immediately engages the officer, sees what he's doing, sees if he has a shot, plans it out. Then he gets back in the car. He told us in his interview the rifle was in the back seat. Gets in the car, reaches to the back seat to the rifle that he'd already put there and was ready to go. He gets the rifle out, he aims it at Officer Teeber, and he fires that rifle 14 times. See, that's the intent to kill. After he exercised reflection and judgment, and he had decided to do that before that 14th shot was fired. He decided to do that before the first shot was fired. He decided to do that while he was driving up here from Louisiana. And after that, he runs off in the woods. After Officer Teeber starts firing back at him, and it's no longer just a one-way shooting, he starts running. He hides in the woods, and he leads officers on a multi-day manhunt.
So he pulled you over, and just because he pulled you over, you got out and shot at him?
Fainted. Fainted. Fainted.
Fainted?
Oh, he fainted. You lost consciousness? I was very tired.
Did you see the officer was a white cop?
Mm-hmm.
So if it was a black cop, would you have done the same thing?
Yeah.
Just because he pulled you over, you got out and shot at him. Did you see it was a white cop? Yeah. If it was a black cop, would you have done the same thing? Yeah. You see, it didn't matter if Officer Teeber was white, black, green, blue, yellow, or purple. This man wanted to kill him because he was a police officer. That's why he wanted to kill him. He was a police officer. And I want you to remember, B.J. Brown was driving without a license. B.J. Brown was driving a car that wasn't registered to him. B.J. Brown had drugs in his car, 170-something pills. Agent testified to you, methamphetamine. And then B.J. Brown had a warrant out for his arrest. It didn't matter what law enforcement officer pulled him over, he was gonna kill him. That's all he cared about. There's one more thing that I want you to think about. Why do you think Mr. Brown immediately got out of his vehicle? Remember, he had a rifle. If he decided to stay in his in his vehicle when the patrol car came up behind him, how easy is it to shoot from the inside of a vehicle when you have a rifle, trying to get it up to your shoulder and trying to aim? If he gets out of the car, he can see what's going on. He can see how the officer is going to react. He can see where the officer is at, and he can easily aim his rifle. He'd had time to plan this. He didn't have time to plan that when he stopped, because you saw when he stopped, he immediately got out. That had to have been thought through beforehand. He immediately gets out knowing that he'll have the advantage at that point. And he attempted to kill Officer Tieber for doing his job. He premeditated it. He intended to kill him because he was a police officer who was doing his job. And we ask you to find him guilty of it.
Brad?
Judge, the defendant will waive closing argument and ask that the court proceed to instruct the jury on the law. Thank you.
All right. And these to the jury, please. Ladies and gentlemen, I'm going to give you your individual copy of the final charge of the court. All right, ladies and gentlemen, if you'll read along with me. Ladies and gentlemen of the jury, the defendant, B.J. Brown, is charged in count 1 with the attempted first-degree murder. Necessarily included within a charge of attempted first-degree murder are the lesser included offenses of attempted second-degree murder and attempted voluntary manslaughter. The defendant is charged in count 2 in the indictment with the crime of unlawful possession of a firearm during the commission of a dangerous felony. The defendant is charged in count 3 with the crime of unlawful employment of a firearm during the flight or escape from the commission of a dangerous offense. Necessarily included within a charge of unlawful employment of a firearm during the flight or escape from the commission of a dangerous offense is the lesser included offense, unlawful possession of a firearm during the commission of a dangerous offense. The evidence and arguments in this case have been completed, and it is my duty now to instruct you as to the law. The law applicable to this case is stated in these instructions, and it is your duty to carefully consider all of them. The order in which these instructions are given is no indication of their relative importance. You should not single out one or more of them to the exclusion of another or others, but should consider each one in the light of and in harmony with the others. The law presumes that the defendant is innocent of the charges against him. This presumption remains with the defendant throughout every stage of the trial, and it is not overcome unless from all of the evidence in the case you are convinced beyond a reasonable doubt that the defendant is guilty. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt, and this burden never shifts but remains on the state throughout the trial of the case. The defendant is not required to prove his innocence. Reasonable doubt is that doubt created by an investigation of all of the proof in the case and an inability after such investigation to let the mind rest easily as to the certainty of guilt. Absolute certainty of guilt is not demanded by the law to convict of any criminal charge, but moral certainty is required, and this certainty is required as to every element of proof necessary to constitute the offense. The state must prove beyond a reasonable doubt all of the elements of the crime charged, that the crime, if in fact committed, was committed by this defendant in Houston County, Tennessee, and that it was committed before the finding and returning of the presentment in this case. As heretofore stated, in count 1 in the indictment, the defendant is charged with the crime of attempted first-degree murder. Any person who commits the offense of attempted first-degree murder is guilty of a crime. For you to find a person guilty of attempted first-degree murder, the state must have proven beyond a reasonable doubt the existence of the following essential elements. That the defendant intended to commit first-degree murder, and 2, that the defendant did some act intending to cause an essential element of first-degree murder to occur, and at the time believed that the act would cause the element to occur without further action on the defendant's part. And 3, that the alleged victim was a law enforcement officer who was engaged in the performance of official duties, and the defendant knew or reasonably should have known that the victim was a law enforcement officer engaged in the performance of official duties. Knew and known means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to the result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. Intended, intending, intent means that a person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. Law enforcement officer means an officer, employee, or agent of a government who has a duty imposed by law to maintain public order or to make arrests for offenses, whether that duty extends to all offenses or is limited to specific offenses, and to investigate the commission of or suspected commission of offenses. The essential elements necessary to constitute first-degree murder are: one, that the defendant unlawfully killed an alleged victim; two, that the defendant acted intentionally. A person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. A defendant's conscious objective need not be to kill a specific victim. If you find beyond a reasonable doubt that the defendant intended to cause the result, the death of a person, and that he did so with premeditation, then the killing of another, even if not the intended victim, would be first-degree murder. And three, that the killing was premeditated. A premeditated act is one done after the exercise of reflection and judgment. Premeditation means that the intent to kill must have been formed prior to the act itself. It is not necessary that the purpose to kill pre-exist in the mind of the accused for any definite period of time. The mental state of the accused at the time he allegedly decided to kill must be carefully considered in order to determine whether the accused was sufficiently free from excitement and passion as to be capable of premeditation. If the design to kill was formed with premeditation, it is immaterial that the accused may have been in a state of passion or excitement when the design was carried into effect. Furthermore, premeditation can be found if the decision to kill is first formed during the heat of passion, but the accused commits the act after the passion has subsided. The flight of a person accused of a crime is a circumstance which, when considered with all of the facts of the case, may justify an inference of guilt. Flight is the voluntary withdrawal of oneself for the purpose of evading arrest or prosecution for the crime charged. Whether the evidence presented proves beyond a reasonable doubt that the defendant fled is a question for your determination. The law makes no precise distinction as to the manner or method of flight. It may be open, or it may be a hurried or concealed departure, or it may be a concealment within the jurisdiction. However, it takes both a leaving the scene of the difficulty and a subsequent hiding out, evasion, or concealment in the community, or a leaving of the community for parts unknown to constitute flight. If flight is proved, the fact of flight alone does not allow you to find the defendant guilty of the crime alleged. However, since flight by a defendant may be caused by a consciousness of guilt, you may consider the fact of flight, if flight is so proven, together with all of the other evidence when you decide the guilt or innocence of the defendant. On the other hand, an entirely innocent person may take flight, and such flight may be explained by proof offered or by facts and circumstances of the case. Whether there was a flight by the defendant and the reasons for it and the weight to be given to it are questions for you to determine. If you find the defendant guilty of attempted first-degree murder as charged in count 1 of the indictment, you shall so state and proceed to count 2. On the other hand, if you do not find the state has proven beyond a reasonable doubt the guilt of the defendant, or if you have a reasonable doubt as to his guilt of attempted first-degree murder, then you shall acquit the defendant of this offense and proceed to inquire as to whether or not the defendant is guilty of the lesser offense of attempted second-degree murder. Any person who commits the offense of attempted second-degree murder is guilty of a crime. For you to find the person guilty of criminal attempt, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant intended to commit the specific offense of second-degree murder, and 2, that the defendant did some act or caused something to happen that would have constituted second-degree murder if the defendant's beliefs at the time he acted had in fact been true. The essential elements necessary to constitute second-degree murder are 1, that the defendant unlawfully killed the alleged victim, and 2, that the defendant acted knowingly. Knowingly is previously defined. Intentionally means that a person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. The defendant's conscious objective need not be to kill a specific victim. If you find beyond a reasonable doubt that the defendant intended to cause the result, the death of the person, then the killing of another, even if not the intended victim, would be second-degree murder. If you find the defendant guilty of attempted second-degree murder as a lesser-included offense of attempted first-degree murder, you shall so state and proceed to count 2. On the other hand, if you do not find that the state has proven beyond a reasonable doubt the guilt of the defendant, or if you have a reasonable doubt as to his guilt of attempted second-degree murder, you shall acquit the defendant of this offense and proceed to inquire as to whether or not the defendant is guilty of the lesser offense of attempted voluntary manslaughter. Any person who commits the offense of attempted voluntary manslaughter is guilty of a crime. For you to find a person guilty of a criminal attempt, the state must have proven beyond a reasonable doubt that the defendant intended to commit the specific offense of voluntary manslaughter, and that the defendant did some act or caused something to happen that would have constituted voluntary manslaughter if the defendant's beliefs were at the time he acted had in fact been true. The essential elements necessary to constitute voluntary manslaughter are 1, that the defendant unlawfully killed the victim, the alleged victim, and 2, that the defendant acted intentionally or knowingly, and 3, that the killing resulted from a state of passion produced by adequate provocation from the alleged victim, sufficient to lead a reasonable person to act in an irrational manner. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation from the alleged victim, sufficient to lead a reasonable person to act in an irrational manner. If you find the defendant guilty of attempted voluntary manslaughter as a lesser-included offense of attempted first-degree murder, you shall so state and proceed to count 2. On the other hand, if you do not find the state has proven beyond a reasonable doubt the guilt of the defendant, or if you have a reasonable doubt as to his guilt of attempted voluntary manslaughter, you shall acquit the defendant of this offense and proceed to count 2. As heretofore stated in count 2 in the indictment, the defendant is charged with unlawful possession of a firearm during the commission of a dangerous offense. Any person who commits the offense of unlawful possession of a firearm during the commission of a dangerous offense is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant possessed a firearm, and 2, that the possession was with the intent to go armed during the commission of or attempt to commit a first-degree murder, and 3, that the defendant acted intentionally. Firearm means any weapon that will or is designed to be, or may readily be converted to expel a projectile by the action of an explosive. If you find the defendant guilty of unlawful possession of a firearm during the commission of a dangerous offense, as charged in count 2 in the indictment, you shall so state and proceed to count 3. On the other hand, if you do not find that the state has proven beyond a reasonable doubt the guilt of the defendant, or if you have a reasonable doubt as to his guilt of unlawful possession of a firearm during the commission of a dangerous offense, then you shall acquit the defendant of this offense and proceed to count 3. As heretofore stated in count 3 in the indictment, the defendant is charged with the crime of unlawful employment of a firearm during the flight or escape from the commission of a dangerous offense. Any person who commits the offense of unlawful employment of a firearm during the flight or escape from commission of a dangerous offense is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant employed a firearm. 2, that the employment was during the flight or escape from the commission of or attempt to commit first-degree murder. And 3, that the defendant acted either intentionally, knowingly, or recklessly. Intentionally means that a person acts intentionally with respect to the nature of the conduct or to the result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Knowingly means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to the result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. Recklessly means that a person acts recklessly with respect to circumstances surrounding the conduct or the result of the conduct when a person is aware of but consciously disregards a substantial and unjustifiable risk that the circumstances exist or that the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all of the circumstances as viewed from the accused person's standpoint. If you find the defendant guilty of unlawful employment of a firearm during the flight or escape from the commission of a dangerous offense as charged in count 3 in the indictment, you shall so state. On the other hand, if you do not find the state has proven beyond a reasonable doubt the guilt of the defendant, or if you have a reasonable doubt as to his guilt of unlawful employment of a firearm during the flight or escape from the commission of a dangerous offense, then you shall acquit the defendant of this offense and proceed to inquire as to whether or not the defendant is guilty of the lesser offense of unlawful possession of a firearm during the commission of a dangerous offense. The elements for unlawful possession of a firearm during the commission of a dangerous offense are set out in count 2. If you find the defendant guilty of unlawful possession of a firearm during the commission of a dangerous offense, you shall so state. On the other hand, if you do not find that the state has proven beyond a reasonable doubt the guilt of the defendant, or if you have a reasonable doubt as to his guilt of unlawful possession of a firearm during the commission of a dangerous offense, you shall acquit the defendant of this offense. It is your duty as jurors to consult with one another and to deliberate with a view to reaching an agreement, if you can do so without violence to individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous. But do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. The verdict must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agree thereto. Your verdict must be unanimous. You can have no prejudice or sympathy or allow anything but the law and the evidence to have any influence upon your verdict. You must render your verdict with absolute fairness and impartiality as you think justice and truth dictate. When you retire to the jury room, you will first select one of your members as foreman or forelady who will preside over your deliberations. When you reach the verdict, you will return with it to this courtroom and your foreman or forelady will announce it. If you have a reasonable doubt of the guilt of the defendant as to the offense charged in the indictment, you shall return a verdict of not guilty. If you find the state has proven the defendant guilty beyond a reasonable doubt, then you should find him guilty. In that event, your foreperson will report you find the defendant guilty. On the other hand, if you find the state has not proven beyond a reasonable doubt the defendant's guilt, or if you have a reasonable doubt as to his guilt, then you must find him not guilty. In that event, your foreperson will report that you find the defendant not guilty. If from the proof you find the defendant has committed a crime other than that for which he is on trial, you may not consider such evidence to prove his disposition to commit such a crime as that on trial. This evidence may only be considered by you for the limited purpose of determining whether it provides motive. That is, such evidence may be considered by you if it tends to show a motive of the defendant for the commission of the offense presently charged and/or the defendant's intent. That is, such evidence may be considered by you if it tends to establish that the defendant actually intended to commit the crime with which he is presently charged. The crime charged in each count in the indictment is a separate and distinct offense. You must decide each charge separately on the evidence and the law applicable to it. The defendant may be found guilty or not guilty on any or all of the offenses charged. Your finding as to each crime charge must be stated in your verdict. If after your deliberations you find the defendant guilty of any offense, the court will set the punishment at a separate sentencing hearing. The jury will not be involved in setting the punishment. When you retire to the jury room, you will first select one of your members as a foreman or forelady who will preside over your deliberations. When you reach the verdict, you will return with it to this courtroom and your foreman or forelady will announce it. In reaching your verdict, you shall first consider the offense charged in each count of the indictment. If you unanimously find the defendant guilty of that offense beyond a reasonable doubt, you shall return a verdict of guilty for that offense as to that defendant. If you unanimously find the defendant not guilty of that offense or have a reasonable doubt of that particular defendant's guilt of that offense, you shall find the defendant not guilty and you shall then proceed to consider whether or not the defendant is guilty of the next lesser included offense in order from greatest to least. if a lesser included offense is included. You shall not proceed to consider any lesser included offense until you have first made a unanimous determination that the defendant is not guilty of the immediately preceding greater offense, or you have unanimously reached a reasonable doubt, unanimously have a reasonable doubt of that particular defendant's guilt of that offense. If you have a reasonable doubt of the guilt of the defendant as to all offenses charged and included in each count of the indictment, you shall return a verdict of not guilty as to that count. If you find that the state has proven the defendant guilty beyond a reasonable doubt, then you should find him guilty. In that event, your foreperson will report you find the defendant guilty and will name the offense agreed upon. On the other hand, if you find the state has not proven beyond a reasonable doubt the defendant's guilt, or if you have a reasonable doubt as to his guilt, then you must find him not guilty. In that event, your foreperson will report that you find the defendant not guilty. The defendant is charged in 3 separate counts of this indictment. Although the cases are being tried together, they are separate and distinct cases. You must decide each case separately on the law and the evidence applicable to it, just as though each case is being tried separately. You'll be asked to render a verdict as to each count of the indictment. You are reminded that you are required to report a verdict or a failure to agree on all counts of the indictment. Ladies and gentlemen, to assist you in your deliberations, I've prepared a verdict form, and that will go back with you for your deliberations. It deals with count 1 and states, as to the charge in the indictment, the charge of attempted first-degree murder, the jury finds the defendant either guilty or not guilty, and allows you to make that determination. Then you move to the next one. As the instructions state, you only consider lesser included offenses if you have found not guilty or a reasonable doubt of guilt as to the original charge. With that, you may now retire to the jury room and begin your deliberations. I would tell you that if you will have certain exhibits that will go back with you, but if you need to see anything regarding the video or the photographs that were demonstrated on the screen, you will need to necessarily come back into the courtroom to be able to see that. At this point, before you retire to begin deliberating, I will select randomly 2 of you who will be alternates, and that means you will not have to decide this case. All right, Ms. Leslie, we're ready. The jury has returned or has advised that they have reached a verdict, so we're going to bring the jury in. Ladies and gentlemen, I'm advised that you have been able to reach a verdict. Is that correct? Yes, sir. Foreman or forelady, would you please stand? As I'm going to go over the verdict form with you, and if you'll just let me know the response. As to count 1 in the indictment on the charge of attempted first-degree murder, how does the jury find the defendant not guilty or guilty? As to count 2 of the indictment on the charge of unlawful possession of a firearm during the commission of a dangerous offense, does the jury find the defendant guilty or not guilty? Guilty. Count 3 of the indictment, does the jury find the defendant guilty or not guilty of the charge of unlawful employment of a firearm during the flight or escape from the commission of a dangerous felony? Guilty. All right, thank you. You can have a seat. Hand that, if you will, to them. Ladies and gentlemen of the jury, I need you to all signify by raising your hand if this is the unanimous verdict of all 12 of you. Let the record reflect that all 12 have indicated it is a unanimous verdict, and I affirm that verdict. Ladies and gentlemen, I thank you for your time. I know it's taken up 3 days of your life for us to do this. It's an important case, as you well know. We are going to now deal with the setting of a sentencing hearing for me to deal with the sentence to be imposed. But you have our thanks, my thanks, and the thanks of all the parties involved for your conscientious service as a juror. I wish I could tell you that would terminate your service for this term of court, but I can't do that because we always need jurors. So if you'll just check that sheet they've given you as to whether or not you need to call back in, we'll let you go today. So thank you for your help. And if you'll go with Officer Howell, he can let you get anything you need out of the jury room and turn in your badges and your notebooks. Thank you. Need to set a sentencing hearing
preliminarily, we'll waive the 45 days on that.
Well, I would like to set it in either February or March, simply because of the fact that that's March is my regular term here, so it would make sense to be able to do it on that day. The 12th of March is the date for our criminal docket call with jail cases. It might be better to do this one on the 11th, which is bail cases. That's usually a shorter docket. March the 11th.
My only problem with that is I have a vehicular homicide leading right up to that, and this being a life without parole case, I need just a little bit of time to prepare for that, more than a normal sentencing hearing. If we could do it later in March, March is fine.
We can do it on the 26th day of March. That's the violation of probation day where there is bail, 26th day of March.
That'll be fine with me, Your Honor.
Mr. Crouch?
What time would that be?
What?
What time would that be?
We can set it for that afternoon if that would work.
I'm teaching class that morning, but if we could, that afternoon, yes.
Teaching a class.
In-service training, yes.
All right. 1:30 in the afternoon on the 26th day of March. We'll need to have an order for a pre-sentence report. All right. Mr. Brown is remanded to the custody of the Sheriff's Department pending the sentencing hearing on the 26th. That is, at that time, the court has reviewed the statute and agrees with the state that the determination of the sentence, including whether or not the defendant will be sentenced to life without parole, as that new statute provides, will be determined by the court after that sentencing hearing.
Your Honor, the final matter, and I promise this is the final matter, could I ask that Mr. Brown be transported to Dixon County a couple of days earlier?
Unless you have any problems in transporting them a couple of days before. 26th is the date, so that's a Tuesday, if we could bring him here on over the weekend.
That would be great.
Would that be possible? All right, that's fine. Just show that he'll be transported prior to that time. Anything else before we adjourn this case?
No, Your Honor.
All right, then we stand adjourned.
All right.